Hi, I'm Jessica Eaves Mathews. So imagine this. You open your inbox or your mailbox, and there it is, a cease and desist letter accusing you of trademark infringement. Maybe it says that you're using somebody else's brand name. Maybe it demands that you stop immediately or face legal action. And it may even mention the amount of money they're trying to get out of you for the infringement. Your heart stops, your brain goes into panic mode. Take a breath. You are not powerless and you are not automatically in the wrong. And you're not automatically going to have to pay money, by the way, because that seems to be the biggest question I get. Today, I will walk you through exactly how to handle a trademark cease and desist calmly, strategically, and legally, and how to protect your business in the process. First things first, don't ignore it. And don't reply right away. In fact, don't reply. It's tempting to fire off an emotional response and say something like, "This is ridiculous. I've been using this name for years," but that can backfire in a major way. So don't do that. Instead, pause, breathe, and then, and I know this sounds self-serving, but I mean it, call a trademark lawyer who knows how to read between the lines. Not every cease and desist is legitimate. Some are just intimidation tactics, sometimes even from a business that doesn't actually have enforceable rights. Let me just give you an example. I had a client who got a cease and desist from a major company claiming she was infringing on their trademark, but they didn't even have a valid registration in her industry. Of course, she didn't know that when she got the letter. They were a very famous mark, and they were trying to own the mark exclusively in all industries, which is not the way it works with trademark law. And I'm sure that they were used to contacting small business owners directly and scaring them into rebranding and them not even calling a trademark lawyer to get help before just capitulating. But that is not a small thing to rebrand. This client was an apparel brand, and she not only professionally designed and had a branded website and social media presence, but as a product-based company, she had printed branded packaging. She had branded hang tags and the labels sewn into each piece of clothing that she sold. She had branded ad campaigns, expensive signage for in-person pop-up shops, of course, printed business cards, business letterhead, branded invoices, receipts. She'd been regularly featured in apparel magazines and shopping guides. So a rebrand was a big deal. And it could be extremely expensive. But I mean, when I say that the labels were in the apparel, that she would have to go through each piece of inventory to rebrand, right, with the hang tags and the labels. So this was going to be extremely expensive. But because she called me smartly, I knew that they could not likely claim a trademark in her industry. And so I pushed back. I responded calmly but firmly with proof that they lacked not only a registered mark, but also what is called a common law mark in that industry, meaning they've never used the mark in that industry. They tried several times to get us to budge, but we basically called their bluff because the law was on our side, and they backed off within a month. She didn't have any expenses except the amount of time that I put into it, which was a fraction of what they were claiming, and she didn't have to rebrand. I had another client who was just launching, and he was using a word that contained the word of another famous mark, also who did not sell what he sold at all. And in this case, there were some components, though, that could potentially be in the items that he was planning to sell. And so some electronic components. And so through a carefully planned negotiation, I was able to get them to come to an agreement so that the famous mark holder would allow my client to continue using the name as long as he didn't use those specific components in his goods. So that was a great outcome for him. He didn't have to rebrand, and he was able to continue moving forward with his business. Now, I can't promise these types of outcomes for everyone, but knowing how to respond to a cease and desist is vital. And knowing there's a way to respond that allows you to keep your brand is also hopefully some comfort. Okay, so the next step after you get a cease and desist letter is to verify whether the sender actually owns what they say they own. So you got to ask these questions, and ideally you're going to get a trademark lawyer involved in this analysis. But the first question is, do they have a federal trademark registration with the United States Patent and Trademark Office? Second, is that registration active and valid? Sometimes it might be canceled because they didn't renew it, or maybe they never used it. And finally, does it cover the same types of goods or services that you sell? If the answer to any of those is no, then their claim might be weak, even baseless. And let me just say, with the same types of goods or services, it doesn't have to be identical, but they have to be the types of goods or services that consumers might think that one company was actually the one selling when it was the other company. So it has to be the type of good that a consumer would think it came from the wrong company. So they don't have to be identical, but they have to be related and similar enough that consumers would be confused, because that's the most important thing to the USPTO. Let's also talk about common law rights. I mentioned that in a minute. That means an unregistered use of a trademark. So they've been using the trademark, but it's not registered with the USPTO. In that case, their rights are limited and limited to their local region, not nationwide. So that makes their claim, the people sending the cease and desist, weaker. And this ties back to another video that I've done in the past, what happens when you don't register your trademark. So if you missed that one, go back and watch it. It explains exactly why registration changes the power dynamic in situations like this. Let's talk about what happens after we verify their rights. We're going to turn to your rights, because that's the next question. If you've been using your name longer than they have, and especially if you've been using it in your area, your geographic area, consistently, you may have common law rights, and that may give you priority rights in that mark through your use of the mark, which means if you were using it first anywhere in the US before this other company, then you may actually have priority rights, even if you guys are not in the same geographic location. Again, you need a seasoned trademark lawyer to help you analyze this, but there is a chance that you may actually come out on top as the priority rights owner or the senior user in this case, and the other party who sent the cease and desist may regret ever having reached out to you. If you've already filed your own federal registration application, you're even in a stronger position, because at least you're on file with the USPTO if you haven't gotten all the way through the examination process yet. If you're not using your mark yet, that's a problem, because that means you don't have any use-based rights. And so our strategy would be different then if that was the case. But let's assume that you are using the mark. The next question would be, are the two marks really confusingly similar? Would they likely confuse a consumer between who they were getting their goods or services from? Trademark law does not protect words in isolation in the US. It protects how they're used in context. So you have to look at the industry. You have to look how both marks are being used. We're going to look at your visual branding and their visual branding. We're going to look at the industries that you're both in. And we're going to look at how your customers encounter your brands. For example, one company might sell only on a wholesale basis, and the other company might sell only directly to consumers. If that's the case, the buyers of those two marks are different, and there's not likely going to be confusion. So sometimes marks can peacefully coexist because they actually operate in totally different markets. Once we've looked at that and we've reviewed both sides, then we're going to make a decision about how to respond. So there are generally 4 paths for responding to a cease and desist. Number 1 is pushback. If the claim is weak, or if the marks aren't confusingly similar, we can respond, again, with a legal letter disputing their claim. Again, hopefully you're having a lawyer draft this for you, because anything that you put in a letter like that could be used against you in litigation by the other side. So you need to know how to make sure that doesn't happen so that you can begin to negotiate. And you don't want to be making admissions to them in writing in particular, but even over the phone of any kind, because those things can be used against you. But we can respond with the right kind of letter disputing their claim firmly, professionally, and with the evidence that we have found. Number 2, this is a different path. If we think both marks can peacefully coexist, then we can suggest that we draft a coexistence agreement and propose that to the other side, which will set clear boundaries, like different geographic regions or different markets. Like if one is a wholesale company and one is direct to consumer, they could agree to never encroach on each other and move into the other space. Things like that. Or maybe one is in California, one is in New York. They could agree to stay geographically distinct. The third possible path is a voluntary rebrand. And this does happen, I'm sorry to say, but if they have clear priority and a strong case, and again, a good trademark lawyer will be able to help you analyze this, then it might make business sense to pivot. Strategically rebranding in that scenario can be far cheaper than a lawsuit. I have one client that had a very successful beauty company who got a cease and desist letter, and ultimately the decision was made, even though there was branded merchandise, branded packaging, branded even a storefront. The decision was made to rebrand because the money spent on the lawsuit would be better spent on rebranding. And it turned out to be the absolute best decision that my client could have made. And her brand is stronger than ever as a result. So sometimes a voluntary rebrand is the right thing to do. And the fourth potential path is you need to file your own application if you haven't. So if you haven't already, this is the perfect time to secure your federal registration if it's available to you and formally protect your side. And often we do that one in conjunction with one or two, especially one. Sometimes we have to hurry and file a trademark registration in the process of responding to a cease and desist. I have several clients that are in that position right now who have received cease and desist from users that started using the mark after they did. But my clients did not consult with a trademark lawyer, did not get federal registration, and now they're having to scramble to get federal registration in the midst of also responding to a cease and desist. So that happens pretty commonly. And so I always recommend filing your application to get federal registration, regardless of how long you've been in business, because it will help prevent these types of problems in the future. So here's what you should never do with a cease and desist. And I mentioned this briefly earlier. Number one, don't ignore the letter. Silence can make it seem like you're admitting guilt, but also it can just motivate them to push harder. And sometimes if you just ignore it, they may go ahead and sue you. So it doesn't mean just because you ignore it that they're going to go away. If they're serious about it, you may end up getting served with a lawsuit. Number two, don't post about it online. I promise this can only make things worse. I actually saw somebody recently on TikTok that just got a cease and desist, and the mark is identical to another brand. The goods are not exactly the same, but they are both in the beauty industry. Instead of consulting with a trademark lawyer, this business owner went straight to TikTok crying about how they were being picked on by this much bigger company, and just basically admitting their use and basically creating a record that the other side could use against her in litigation. So don't do that. As much as you want sympathy and maybe you want a GoFundMe campaign or something to help you, don't do that before you talk to a trademark lawyer. And third, don't make promises you can't keep without legal advice. Please don't respond to a cease and desist letter without legal consultation. I have so many people that have come to me after they've received a cease and desist and they've responded already and created a record that then I have to try to overcome and correct in order to protect my client. So you could be making your trademark lawyer's job very difficult if you begin negotiating without having a lawyer. So don't make promises that you can't keep without legal advice. Let your lawyer handle the communication. That's what we're trained for. So the best way to avoid ever getting a cease and desist again, register your trademark and register it as early as you possibly can and audit your brand assets regularly. A good trademark lawyer can help you do what's called a trademark audit and look through your business and make sure that your brand assets are ones that you can own exclusively. They're not infringing on somebody else's rights, and make sure that we protect them through a federally registered trademark. If you're using names, logos, or taglines that have not been cleared, and cleared means that a trademark lawyer has done the research and has told you that the mark appears to be available to you to use, then you're inviting risk constantly. And that's exactly why I do trademark and IP audits for founders, to uncover issues before they turn into emergencies. So if you received a cease and desist, or you're worried that you might, let's talk. Set up a free consultation with me, and I can help you figure out what your level of risk is and how to protect yourself now. And if you've gotten a cease and desist, I'll review the letter, analyze your risk in that particular dispute, and help you respond calmly and strategically. No panic, no guesswork. So schedule your trademark strategy call today, and then we can help you respond with strategy, not fear. Oh, and before I let you go, some of you may have a question about how to protect yourself, not just in the US, but in other markets. And in my next video, we're going to take this conversation global, because once you've protected your brand in the US, the next question is how to protect it internationally. And I'll explain how international trademarks work, when you need them, and how to make sure someone overseas doesn't steal your brand name while you sleep. So stay tuned for that next video.